Hello folks, Don Rolfe here with Northwest Legal Planning, and I'm here to answer another common question that I get from people that contact me about estate planning, and that is, what is in an estate plan? And that really depends upon how sophisticated you want to be as to what's in an estate plan. If you have further questions about this, or you want to talk to me about any other estate planning issue, please go to myestateplanmeeting.com and you can schedule a complimentary half hour with me to get those questions answered and learn about your estate planning options. So what is in an estate plan? Right now, if you've done zero estate planning whatsoever, you do have an estate plan. I've told you this a few times, I believe, in some of these videos, and your estate plan was put together by the legislature in the state that you reside in. So if you're here in Oregon, the Oregon legislature has passed laws that have put together an estate plan for you. So if you don't have any documents put together, such as a will, and you pass away, you are said to have died intestate, and that means that you did not have your last testament, and that your assets will pass pursuant to, hello there, your assets will pass pursuant to the intestacy statutes, which means they'll go to spouse or children or your parents, or there's a whole line of succession that the statutes, hello there Debbie, how you doing? There's a whole line of succession of how your assets will pass in those statutes. Now, if you're actually going to start doing some estate planning, there is a method which is called the poor man's estate plan, which is basically still dying intestate, but people put beneficiary designations or co-ownership on all of their assets. This is something that I highly advise against doing on your own. There can be a lot of implications, especially if you are putting joint owners on your assets, because when you put them on, that is a present gift. So if you put your child on your house, for instance, you do a quitclaim deed so that the house is both you and your child as joint tenants, then that is a present day gift. And if your house is worth, say, $500,000, that's a $250,000 gift to your child right then. And that could mean you have to pay a gift tax. So the quote unquote poor man's method of estate planning is doing the beneficiary designations and co-ownership. Again, do not try to do that on your own, as it can raise some scary issues related to taxes and gifting and so forth. The next is, putting together just a will. That is the base document that you need if you want to make the decisions that are different than the intestacy statute set forth for how your assets are going to be distributed. And if you have children, that is the place where you are going to name guardians for those children, and really that's the only place you can do it. The downside to just having a will is that it doesn't cover any other aspect of your life, such as incapacity, healthcare issues, and so forth. So the next step up is to do a complete estate plan package, which is what I do for my clients. It's a base estate plan package, and all of them, whether it's a trust-based package or a will-based package, will include a will. They will include a power of attorney for if you are incapacitated and someone else needs to manage your affairs. They will include your healthcare documents, the state statutory advance directive. We also do a more traditional healthcare power of attorney to allow your healthcare agent to make decisions for you in areas that are outside the scope of your advance directive. We can do disposition of remain forms, organ donation forms. We also, if you have a trust, we do the trust, we do the certificate of trust, we do transfers of some of your assets. We explain to you how to transfer your assets. There's a whole slew of documents that go into making the plan that we put together work. So that is a base estate plan. Again, if you have any questions about this, you can talk to me directly by going to myestateplanmeeting.com and setting up a consultation if any of this is getting a little too complicated, or perhaps I'm talking a little bit fast. So the step up from the base plan, it really depends on what your assets are and what your goals are. So if you have a highly taxable estate, we may do some sort of gifting trust, some sort of charitable remainder trust. We may do an ILIT, which is a life insurance, irrevocable life insurance trust. to try to get some of your assets out of your estate so that the estate tax isn't going to be something that's going to be a huge burden on your estate after you pass away. There are a myriad of different strategies that we can use. We can use forming family LLCs or family limited partnerships in order to hold certain assets and to be able to do gifting through life easier without actually giving the donee or the person receiving the gift control of the asset right away and letting them come into it throughout time. There are lots and lots and lots of options. But the base plans that I put together usually contain somewhere between 10 and 14 documents. And those plans need all of those documents because we sit down and we determine exactly what your goals are, what your assets look like, and what your family looks like. And we create the documents that are absolutely necessary in order to make those things work for you, to have your plan and your wishes come to a reality once you pass away. I wanted to touch a little bit on, I think I skipped over it, the incapacity portion of estate planning. So if you just have that no estate plan or you just have a will, that only will cover you after you pass away. While you're alive, though, there are times when you may be incapacitated. You may be in the hospital, unconscious, unable to communicate. And at that point in time, you are determined to be incapacitated. You're unable to do things for yourself. So a lot of the other documents that we put together in an estate plan are to cover those periods of time. Whether that be due to, like I said, a medical condition where you're unconscious, or it could be due to dementia, early onset forms of Alzheimer's, or other debilitating diseases. Or it may just be that you have too much on your plate and you want to be able to have someone else do those things for you because you just don't feel you're capable of doing it. And so that's where the power of attorney comes in. And if you have a trust, that's where you turn things over to a successor trustee that can manage all of your things for you. And also those healthcare documents, which are really important so that you have the people appointed that you want making those healthcare decisions for you. Again, if you have any questions about this topic or any other estate planning topic, do feel free to reach out to me. Love chatting with people. And if you go to myestateplanmeeting.com, you can schedule a 30-minute telephone conversation or in person. I prefer in person because I like talking to people and I like hearing their stories, and it just seems like that's a lot easier face to face. Again, we can meet for a half hour. I'll answer your questions for you and get to know a little bit about you and explain to you your options for estate planning. All right, folks, until next time, take care. Bye.